We are recording now, and I'm going to hit broadcast.
Good evening, everyone. My name is Sasha Ferrone, and I'm one of the family lawyers at KPA. Joining me for tonight's live webinar are my family law colleagues, Emily Banks, Preet Panu, and Krishma Saberwal. Tonight's presentation is geared to answer all of your questions with respect to family law. And in terms of a little bit about the firm before we get into tonight's agenda, all four of us, we represent the family law team at KPA. We are located at 200 Matheson Boulevard West in Mississauga. The main intersection is Huron, Ontario and Matheson. Our firm is what you would describe as a full service firm. So we do every aspect of law. I think the only area we don't cover is immigration law. So we do family law, litigation, human rights tribunal, employment law, cannabis law, criminal defense, liquor license law, small claims, business law, real estate, construction liens, wills, and debt collection. In terms of tonight's agenda, Em, do you want to cover that off?
Yes, so first we're going to start off with some COVID-19 updates from the courts. We're going to talk about if the courts are still open, the recent decisions that have been coming out of the courts. Then we're going to talk about some dispute resolution options during COVID-19. Then we're going to switch to some Q&As. We have some that are previously submitted to us through email or Facebook. We're going to be answering those first, and then after that, we're going to be taking any questions from the chat. So the next slide is the different resources that are available to everybody during COVID-19. So as you can see, we have a couple different websites listed. So the OntarioCourts.ca is giving regular updates for the different regions. So if you are in Brampton or if you're Newmarket, that kind of thing, you can see the specifics for each courthouse because they are doing things differently. There's also the website called stepstojustice.ca, and it gives you a really good overview of what's happening during COVID. It also does really good overviews for multiple different types of processes for family law. And lastly, we have our own website and our Facebook or Instagram where we're doing constant updates with COVID-19 as well as general information about family law. Right now, the courts are only open for urgent matters. What's urgent is determinative for different courthouses. Some are allowing some urgent case conferences or just motions. So the resources that we've listed above is very helpful. Then we'll address that the prior court dates are being adjourned and some are just being rescheduled. Some are going to have to be rescheduled with a date set once the courts reopen. It all depends on what courthouse you're looking to. And urgent matters, each court is deciding how they're going to hear urgent matters. Sometimes they're video calls, sometimes they're telephone calls, sometimes they're just in writing.
Okay, so this slide covers family court specifically in Brampton, and urgent matters like Emily discussed include the safety of the child, the safety of parents, or when the finances are involved, for example, issues about the matrimonial home. To file urgent documents, you'd have to do it via email, and this is because the judges don't have access to physical files. So when we're submitting urgent matters in family matters during COVID, it needs to be in a 2-page letter that state, the relief that you're requesting, why the matter is urgent, any draft orders, and confirmation that this motion can be heard via teleconference. And you'd have to indicate how service on opposing counsel or opposing party was made, unless it's ex parte, which means a without notice motion. Include any relevant prior orders, endorsements, and hyperlink any case law. The scheduling of the hearing will be based on the trial coordinator, and the hearing, as Emily motioned, would be via telephone, video conference, or all written.
Great, thank you.
So to discuss access during COVID-19, I know it's a huge issue for a lot of parents, and that's the main reason we're going to be speaking about access during COVID in a lot of depth. We'll also be answering many questions that are being asked by our fellow listeners later on, mainly to do with access and custody during COVID-19. So currently, the courts have pretty much said that if you have access and you have a court order in place and you have a separation agreement in place, you must follow it. There are exceptions to that must follow it, but you have to allow your child to see the other parent. You have to keep your child in a routine. That's pretty much what they're saying. The best interest of the child is to keep the child in routine. COVID-19 is not an excuse at all to withhold access, and in simpler terms, that's what it means. So unless it's an emergency that your child not go to the other parent, you must follow the order and the separation agreement that is in place. Sasha, if we can move on to the next slide. So some of the factors that judges have considered in matters that are being brought on an urgent basis before the court for custody and access. Some of the factors we've listed here, not some of them actually, they are the main factors that the judges are considering when parents are bringing forth motions or case conferences on an urgent basis to do with their children and access. So what a parent who is initiating the motion must do is that they must prove to the court with concrete evidence that there is a problem with access. You can't simply just state it in a sentence, you must have proof. So there must be either messages that have been going back and forth between the parties, or a genuine issue that needs to be brought before the court for the court to assist you in determining. Even in circumstances where you need the court's assistance, the court is encouraging all parents to start talking to each other and figure out what's best for the child. And you have to show the court, on top of what the big problem is, the utmost bigger problem, I would say, is that the parents aren't able to communicate about how to alter access during COVID-19 or how to make sure that the child is safe in both parents' care. So when you're not able to determine those issues, that's when the courts are assisting, I guess. That's the best way to put it. If parents can't figure it out, the courts will assist. The responding parent in a situation where a parent has initiated an urgent motion has to provide the court assurances that they are following the COVID-19 safety measures, and they are social distancing, and they're disinfecting, and they're following what the government is saying with regards to health and safety in regards to COVID-19. So that's kind of where your responding material to the court is going to play a role in how the court is going to determine how this access issue is going to move forward. And both parents have to provide realistic proposals. If you can't figure it out between the two of you, then and you're getting the court involved, you still have to tell the court what is reasonable in your eyes for your child to make sure that both parties are having access and both parties are willing and standing by their child to make sure that the child is going to be in a perfectly normal psychological state and not being harmed in any other way. So and to sum it all again, you must allow your child access unless there is a problem with one or the other parent not following the COVID-19 safety protocols.
That's great.
So I'm just going to read out some of the sentiments from the bench, and this might allow you to understand what the court's impression is about access. So one of our judges actually laid it out in a case very simply, one of the very first cases that came out. Children's lives and are vitally important and vitally important family relationships cannot be placed on hold indefinitely without risking serious emotional harm and upset. A blanket policy that children should never leave their primary residence, even to visit their other parent, is inconsistent with a comprehensive analysis of the best interest of the child. And pretty much the judges saying exactly what we just covered in the other slides, that you can't keep a child away from the other parent just because there's a pandemic going on. The other parent of the child is perfectly capable of taking care of the child. The judge continued to say a presumption that existing parenting arrangements and schedules should continue subject to whatever modifications may be necessary to ensure that all COVID-19 precautions are adhered to, including strict social distancing. Children need their parents to act reasonably and responsibly at this time. So I couldn't have summed it up better than what the judges have summed it up in the few words and sentences they've provided us through their case law and urgent motions that have come forth.
So we're going to switch over to child support and spousal support and other financial issues during COVID-19. Sometimes these orders for support can be considered urgent depending on the circumstances, but in general, you're still expected to pay support even if your employment has been affected. You can try to talk to the other party or the other party's lawyer to try to negotiate an interim support reduction or just pause or agree to pay it after you back to work. And then you also need to show that you've applied for the federal funding at what you qualify for. So there has been some cases recently that have dealt with emergencies for support. Usually it hasn't been found as urgent unless you can prove that you're in dire financial need. So whenever you're doing a motion for changing of support, you need to make sure that you're providing an excessive amount of financial disclosure to the judge. You're going to need to show what your income was prior, what your income is now, provide all of your expenses to show that you can't afford to continue to pay your support. You would also need to show that you've tried to apply for the funding and you haven't received it. Now, the big thing is if your support is going through FRO. So FRO is collecting support at the moment, but the cases suggest that they're not doing enforcement. There have been a few cases where people have received the notices that, let's say, their driver's license are going to be suspended, and then they bring an urgent motion. But most times, FRO has sent a following letter saying that they are suspending any enforcement at the moment. So if you have a letter saying that you're going to be having some form of enforcement, I would suggest that you contact FRO first to see what their position actually is before you bring a motion. The next thing is to possibly bring a motion to change later and deal with it at that point. Right now, unless it's an urgent matter, you're not going to be able to file a motion to change. There's also other financial issues that have been coming up during COVID-19. Things like division of property. There's been times where there are people who have the funds from their matrimonial home being held in trust. So there has been a case where the judge allowed for some of the money to be released to the parties on an interim basis so that they can continue to have the funds that they need to survive at this time. But the case is that they're making sure that there's enough money still left in trust in order to deal with any equalization or support issues after COVID-19 is done. So again, the biggest things for any type of financial issue during COVID-19 is to prove that there's a dire financial need. And second, you need to make sure that you have as much financial disclosure to the judge as possible.
In terms of domestic violence, because of COVID-19, self-isolation and social distancing can make it even harder to get help if your partner is abusing you, your children, or another family member that lives in the same home. If you or someone you know is in immediate danger, you should contact 911. If you are in an abusive situation, but you're not in immediate danger, you should think about safe places that you can go in your home or within your community. For example, you can think about community places that are still open during the pandemic, such as police stations or fire stations. It's always good that you keep in touch with friends and family members that can help you if your situation arises to the level of immediate danger. There are great resources in terms of helplines that you can contact. You can call a family lawyer. So right now, for example, at KPA, we are we have suspended consultation fees. So we're offering free consultations, not only for family law matters, but all areas of practice. So you could always contact a member of our team and we could provide you with a list of resources of where you could go in the event that you are in an abusive relationship. Shelters, Interim Place and Peel Family Shelter. They're both in the Peel region and they are currently accepting individuals. And the resource that we've listed, so it's www.sheltersafe.ca. They have a list of shelters and there's tons of information. So if you do find yourself in a domestic violence situation, there is help. In terms of the alternatives to court during COVID-19, so a lot of people are under the assumption that because courts are closed and they're only hearing urgent matters, that their family law matter is paused, and that's not necessarily the case. So on this slide, we have listed a few options in terms of some alternatives to court. So on the left side of the spectrum are options that allow both parties engaged in the family law matter to have the most autonomy, and these are the cheapest options, and they also allow for faster resolutions. On the far right of the spectrum are more costly options, and both parties essentially are saying to either an arbitrator or a judge that, you know, we're unable to come to a resolution, so can you make a decision for us? So one of the options, if you're, you know, even if you've started a family court proceeding or if you've considered that you and your partner need to separate, you can engage in what are called kitchen table discussions. So the idea is that you and your partner could sit down together, whether it's over email or in person, to discuss all of the issues involved in your family law matter, and then decide how each of those issues is to be resolved. So for example, when it comes to a parenting plan, if you have children, you know, during COVID-19 and after COVID-19, what type of parenting schedule will be best for the parents and the children. And the idea is that you take that kitchen table discussion and you give it to a family lawyer, and that lawyer can assist you with drafting what's called a separation agreement, which is a contract between you and your ex that details all of the issues involved in your family law matter. As you move towards the right end of the spectrum is what we call lawyer-lawyer negotiations. So a lot of the work that myself and my colleagues do is referred to as lawyer-lawyer negotiations. So the idea is that my client retains me, the other party has a lawyer, and the lawyers assist both parties in coming to a resolution on all issues. The end goal is then to draft the separation agreement. Collaborative family law is a new and growing area of law that not many people know about. With collaborative family law, I would say all of our lawyers practice collaboratively, but we are not officially trained as collaborative lawyers. Collaborative family lawyers are family lawyers, but they have certain additional training. With collaborative family law, the idea is that usually both parties have lawyers, and then various third parties are involved in the file. So if there are issues with respect to parenting, you might get a social worker involved or a parenting plan coordinator. If there are issues with respect to, you know, one party has a business which needs to be valued, you might hire a financial advisor or someone to do evaluation, and they'll assist in the matter. As you go towards the right end of the spectrum, we have mediation and med-arb, and then arbitration. Mediation is basically where you hire a third party who acts as a neutral. A mediator does not necessarily have to be a lawyer. They could be a social worker, for example, or someone that has more of a financial background. But the idea is that the mediator essentially facilitates communication between the parties. A mediator will not impose a decision, but they will help the parties come to a resolution. And ideally, at the end of mediation, whether it's one session or 5 sessions, the mediator will prepare a summary of what has occurred during mediation, and they will summarize what the parties have agreed to. The idea there is that once you have what's called a mediation report or a mediation summary, the parties take that to their respective lawyers, and one lawyer will then assist with drafting the separation agreement. Med-arb is a combination of mediation arbitration. The idea is that the parties start, or they retain, a mediator / arbitrator. and they will start the process through mediation. If they're able to resolve all the issues through mediation, great. Let's say some of the issues are able to be resolved through mediation, or one issue is resolved through mediation and 2 of the 3 issues aren't, then those issues would then proceed to arbitration. Arbitration is essentially like hiring a private judge. So you're paying that individual hourly or block fees, and they will listen to both sides and they will make a decision. So it's an arbitral award, and that award is binding, just like a court order is. Information, but there are many alternatives to court. So just because courts are closed and they're only hearing urgent matters right now doesn't mean that your family law matter needs to be paused or that it can't start.
So we have some questions that are being asked live, and we also have many slides of questions that have been asked prior to us starting via emails. So let's just take some of these questions that were asked right now, and then we'll go back and forth between the ones we have from before. So one of our participants here, an anonymous attendee, is asking, how can Ontario Court assist in bringing back minor Canadian kids from Middle East/South Asia? Okay, so I'll start by saying, if you have a court order from a Canadian court, some jurisdictions overseas will allow you to take that order to your local courts and see how it can be enforced. Unfortunately, all of the panelists today, we can only speak about Ontario law. We have no jurisdiction to practice or even the knowledge to provide about anything outside of Ontario. So predominantly when we bring kids back from overseas, the jurisdiction where the child is must be part of the convention. So for us to have easy access to that jurisdiction, if they're part of the convention, then we do have a mechanism to bring the child back by using our court system and the policing system that's readily available to everybody in almost in those countries. However, if they're not part of the convention, it becomes very difficult to bring children back to Canada. So that's my answer. If anybody else wants to add on a little bit.
Yes, just to add on to Preeta a bit, when she was saying convention, she means Hague Convention.
Correct.
I think she just missed saying the full name for you guys. Also, I think you're going to have an issue if the children were taken prior to COVID-19 and you didn't do anything about it, and now you're trying to do something about it. They may not feel like it's urgent at this time. As well, you're probably going to need to prove that there's a safety risk for wherever they are, and make sure that you have the availability to be self-isolating if the children get returned to you, because you will have to do the 14 days at home after they return.
Do we want to go to the next question?
Yes, let's go on from the slides.
Yeah. Krishma, I think you wanted to cover this.
So this question, I can read it out for everyone, but basically what I understand is there has been a final minutes of settlement where I believe Jeremy has sole custody of his daughter and mom has sole custody of son. So Jeremy's question is, his previous temporary order states my daughter is to reside with me until July 2020 or until adjudicated by the courts. Can my ex come to my home and remove my daughter and relocate her to Alberta without the court's approval? So Preet touched a little bit on this earlier about outstanding orders. They're still in effect. So in this question specifically, considering the government has put a non-essential travel ban on taking the kids outside of the province or anywhere really in the world, I would say it would be highly unlikely that mom would be able to come and relocate daughter without a good reason or without a good excuse and without a court approval. I don't know if anyone else wants to jump in. Okay.
Yeah.
I think you got it all.
Okay, cool. So that would be how the courts would deal with that would be they'd first look at if there's any outstanding orders, and second, travel. It would be really hard to, in order to leave, you'd have to show that it's in the children's best interest to defy this travel ban.
Yeah. So I've read some cases with recent decisions. Obviously, every case decision is very fact specific. But there was a parent who had taken the child for March break out to the East Coast, and they were due to return prior to the school starting. And in the midst of all of this, the school system was shut down. In that situation, the child was an habitual resident of Ontario, and the urgent motion did grant that the child be returned. And it also went as far as saying that police is allowed to enforce it. They are not allowed to, they are to enforce it. So courts are taking the approach that if there is a court order, you must listen to it. And I don't think it should be any other way, because if you look at in general day-to-day life, if a court has made an order, you should just listen to it. Just read it and listen to it. That's my take on court orders.
You want to do the next one on the slide?
Sure.
Okay. And I think Em was going to take this question.
Yes.
To
So this question is from James, and he's asking how to share or split the child tax benefit when you file for your tax returns as separated and have shared custody of 2 children. And he says that it's his understanding that when married, one person with lower income will claim the child tax benefit. So usually for child tax benefit, when you have more than one child, then you can agree who would be claiming each child, or you can come to an agreement that once child tax benefits is received by one party, then they would be then transferring some money to the other parent. But to make sure you're doing your tax returns correctly, we would say defer to your accountant. But yes, only one person can be claiming one child on their tax returns.
I think Preet was going to start with this one.
Sure. I think I may have answered this via the live question and answer period about children being outside of the country and how to bring them back.
Do you want to maybe number 3?
Yeah, but
That's
the third leg of the question I can answer. How do I sell a house that I own with my former spouse if my former spouse no longer resides in Canada? If your former spouse, first and foremost, is listed on the house as an owner, then it's a little bit more difficult. But if your former spouse is in agreement, perhaps you could get a power of attorney. But I'm going to assume, because we are in a family law webinar, that it may not be something that's on consent. In that case, you would need a court order to not have her sign for the closing documents. And perhaps I should add on to that, even if she is not listed as a part owner on the house, she still has spousal rights. So a real estate lawyer will most likely require a spouse to sign off the documents before it moves title to a different person, despite not being listed on the house.
Okay, and I can take this question. So the question is from Eric. My union is settling a grievance from 3 years ago, which will result in me getting a large amount of retroactive pay, approximately $12,000. Do I calculate that I'm going to make $12,000 more this year, so my new amount to pay is X? Or do I calculate that I now owe X from 2017 and Y from 2018, the years the retro support will actually apply to? So for this question, Eric, and I need to know a little bit more detail, but this is something that I would address with your accountant. So if the $12,000 is going to affect, let's say, your income from 2018, then in terms of calculating child support arrears, it would be applied to that year. Another suggestion is possibly to take an average of the past 3 years. But basically, in terms of calculating retroactive support with child support changes from year to year. And oftentimes people, when they have a court order, they stick to that same amount based on what was ordered, let's say 4 years ago in a court order. However, there is an obligation to exchange income information every single year if you are required to pay support or if the other party is required to contribute to Section 7 expenses. So this information is important because it will affect how much you owe in child support. But this is a question that I would probably defer to the accountant. And depending on when your accountant is applying that, $12,000, depending on what year it's applied to, I would say that that's the year that child support has to be paid. So if as I said, sorry, scrambling a little. So if the $12,000, your accountant deems that it should have been paid and should be reflected in your 2018 income, then the amount of child support arrears from 2018, that's when I would calculate it from. Sorry, that was a bit confusing. Does anyone want to add anything?
Nope.
Okay. And I think Em was going to take the next one.
Yes, so this is a question from Darren. So he says that his son and he were both contacted by the police and instructed to seek an emergency order against the child's mother for the son. So what we can understand from this question is that Darren seems to be the grandfather of the child in question, and the issue is for Darren's son to try to get an emergency order for sole custody because of the child's mother. The police had called CAS and reported their concerns, but CAS is saying that they see no safety issues. What I would say is that CAS will not be removing children from parents unless they deem that they need to. And generally they're involved without having to remove children. They to remove children, they have to bring an emergency motion themselves. So it may be more beneficial and easier to move this along for Darren's son to bring an emergency motion. If he can get information from the police that helps this case, then that would be the best evidence to go forward. That's going forward to the next part of the question. It says that they've called CAS and reported incidents, and that she had Darren's son charged with assault 5 years ago, but it was thrown out because of a lie. And she keeps claiming that her son got away with assaulting her and refusing to help Darren's son in any way. This has led serious concerns for the child's safety. The mother is bipolar and is not taking her medication. She's been arrested several times. So Darren, again, these are definitely some issues that would go towards needing an emergency motion. It's the same kind of thing that we're doing with urgent motions. If you haven't started any sort of court case already, you're going to need to make sure that you are also starting an application as well with your request for an urgent motion. But these are some very concerning allegations. You're going to need as much proof as possible. It would be interesting to know why the police got involved. If it was from a third party, then that would definitely help your case for getting an emergency motion. I wouldn't wait and rely on CAS just because they have different standards of when they can remove children. So I would start your own urgent motion first.
Okay, I think I was going to take this one. So question from Jason. I just found out the hard way by being audited that I'm unable to claim any child on my tax return if I'm paying support. However, it had also recently been brought to my attention that if the children are over a certain number of nights, 5 or 6, that I would be entitled to support as well. And in that scenario, I would be able to claim one of the children on my taxes. The current scenario, so that they have children aged 10, 11. The children reside with him 6 to 7 nights in a 2-week period. I'm receiving a portion of the child tax benefit. Mom's income is higher than mine. I was paying support for both children through FRO. Mom had a lawyer and I was self-represented. We're in court but I settled to avoid trial. So not a specific question in the first part, but I'm going to assume that depending on this question, I guess, would speak to maybe child support, what's called set off. So the idea is that if the children reside with one parent the majority of the time, then the other parent has to pay full table child support to that parent. In this case, and I'm just rereading some of this, if the children, so basically lawyers refer to it as the 40% rule. So if the children reside with both parents at least 40% of the time, there is an argument to be made that set off child support should apply. So basically that means that in this case, we would calculate, okay, well, how much child support does mom owe dad? So let's say it's $100. How much table child support does dad owe mom? Let's say it's $40. And then the difference of $60 is what needs to be paid. So I think that's what that first part speaks to. And then the second part of the question says, relating to COVID times, I've been trying to minimize the odd days of back and forth and have been trying to come to more of a week about scenario, as it would help with minimizing travel, increase quarantine times, and make homework or projects easier to follow through on a complete basis. So again, not necessarily a question there, but I think that's a great suggestion. So given everything that's going on right now with COVID-19, I think the idea of trying to reduce the amount of back and forth makes a lot of sense. And a week about schedule could be a great option right now. I don't know if anyone wants to add anything. Okay.
Well, I think you covered it, Sash.
Okay, and then Krishna was going to take this next question.
So this question is from Justin, and he's asking, what is or will be the court's position on parents who have used the COVID-19 pandemic as a means to keep their children indefinitely from the other parent? Note, there is a court order endorsed consent order in place for joint custody. The child is 2 years old and parents live approximately 4 hours apart. So as I think we've all mentioned before, the judges, based on their most recent endorsements, do not like it if you're withholding access because of COVID-19 pandemic as an excuse. So that would qualify as urgent, considering there is already a outstanding court order in place. Recent case law has shown that 4 hours apart isn't it by itself a means to withhold access. You can figure out other ways to exercise that access, and the 4 hours apart isn't alone a standalone factor. So I'm not sure who has advised you, Justin, that this is not considered an urgent matter, but I would recommend a consultation and figuring out how you can exercise your court-ordered access.
To go off of what Karishma's just answered, there is a question that goes closely to it from Albert Smith in the chat, where he's asking if it's in the best interest for one parent is voluntarily giving up parenting rights while both parents are not able to come to a consensus on the points. So I have seen cases recently where the judges have said that they would not create a new status quo with a parent not having access during COVID-19. If the parents cannot come to an agreement, it's okay for a parent to say that they will not have in-person access right now. It will not be used against them. You could even say that it would be used in their favor to show that they were trying to put the children's rights and their safety before their own rights to access. I would say if you're doing that, then you would want to request some FaceTime or video access so that you can still have a good relationship with your child during that time. But that's an excellent option, Albert.
And I think, Em, you're going to take this next question.
So the first question is, how do you settle property under joint name if it's just a boyfriend-girlfriend relationship, not living together? Is the answer different from common law relationship, but are the guidelines in settling joint name property, bank accounts, car, etc.? So this is from Jay. So Jay, we would say that you would still use the same kind of guidelines for common law property and division. Specifically when it's a joint, then they're going to most likely lean towards 50-50 division. But you have to see if there's a joint family venture and what the different who contributed what to the property. So it's a much more in-depth discussion of how the property would be divided. The same things about other accounts. So anything that's in joint for common law you would have to deal with and have to divide. Anything that is not joint and there is no joint family venture, even if you're not entitled, then that would not be divided in common law relationships because it's not subject to equalization. And then the second question is, for joint custody of a child, how would you determine the amount of child support? So child support is not determined on custody, it's determined on parenting time. So if you mean by joint custody that you have a split parenting time arrangement, so either you're 50-50 time or anywhere between 50-50 and 40-60, there is a process that's called set-off of child support. Now, set-off is not an automatic right. It needs to be argued, and a judge has the decision to decide if it would be applied or not. How to do a set-off is that you look at what either parent would pay for child support if they had the children the full amount of time. So let's say that parent A would have to pay $500 a month if they didn't have the children 50-50, and parent B would have to pay $300. That the set-off would mean that parent A would then pay only child support of $200 a month, which is the difference between the two.
And this question, I think Preet was going to take it.
Sure. I've been trying to answer as many questions as I can in writing. So this question, my ex-husband and I have been separated since September 2019. We both work full-time. We were very close in listing our matrimonial home until the COVID-19 pandemic. We decided to hold off listing the home and are currently living under the same roof. I severed my share of the matrimonial home back in September 2019. At the moment, we do not have a separation agreement in place. However, we did discuss the contents of the agreement. What's mine is mine, what's his is his, pensions, investments, etc. My concern, given the uncertainty of our jobs and in the event I am laid off, am I able to ask for spousal support, vice versa? If you have an income, I'll address the spousal support part first. I know Sasha and I usually like to say in our seminars that we have in person that spousal support is something you have to prove that you are entitled to. It's not an automatic right like child support. So you have to prove to the courts or to the other party, other lawyer, whatever process you are using, that you have the right to spousal support. And that depends on a lot of factors. Factors such as what's your income, what's the other party's income, what kind of lifestyle you had, what kind of lifestyle is changing after separation, and a whole array of other factors. So that's something that is very, very extremely case specific, and I would need a lot more information to advise you whether one party can go for spousal support after the other or vice versa. And as for the matrimonial home, just because you severed your shares in a matrimonial home doesn't mean you lose the right to an equalization of that matrimonial home. You have an entitlement, whether you're listed on the home as a owner or not, to get division via equalization on that property. And if you haven't drafted a separation agreement yet and you've come to the terms of it, you can still hire a lawyer and get that done so that you don't have to wait until after the pandemic. If you've already come to terms, which is what we prefer, most of our clients do, go sit at your home or on the telephone right now and figure out what you want out of life with the other person. They were part of your life, and if you have children together, chances are you're still going to continue to be part of the other person's life. And if you guys can come to terms, which is great, which is what this question says, an agreement can easily be drafted and both of you can sign it, even during the pandemic. Right?
Thanks, Preet. Question from Karen, are there any supervised access options for supervised parenting time available during this time of COVID-19? I don't know if Krishna, did you have a file that was touching on this lately?
This question. You'd have to contact, I know some supervised access centers, for example, Braden Access Center or Canark Access Center, all of them have different protocols with how they're dealing with parenting time. For example, they might not all be fully open or have full capacity. You also have to keep in mind that the City of Toronto, as well as Mississauga, and I think all of Ontario, has suspended park access. So I would suggest, if you have supervised access, if you can come to a mutual supervisor between both parties, you can maybe go for walks, or if in-person access isn't available at this time, like Emily said, definitely take advantage of virtual access, FaceTime, telephone calls. We live in a world of technology. So if supervised access via centers isn't an option right now, there are other ways to exercise your parenting time.
Thanks. And I think just like courts, things are changing quite rapidly. We're receiving weekly updates. Things are changing kind of day to day. So even if an access center, a supervised access center isn't currently open, it might be open within the next week. So I think you should be constantly, exactly.
Yeah, definitely keep in touch.
Yeah. I think that's all of the questions that I had that were previously sent to me. So I don't know if you want to read out. I know you've been responding to some of the questions. If you want to read out some questions you haven't already addressed.
Yes.
Sorry, Preet, can I just interrupt?
Yes, of course.
I was trying to answer one of Sandra's questions via type and I hit the wrong number. So now I cannot type the answer. She's asked, she has the second part of her divorce to complete now. But unfortunately, Sandra, right now they are stalling divorces. They're not considered urgent matters. So you'll have to wait until COVID-19 is over and the courts are open, or they change the system of how they're going forward and adding more things to what they're dealing with during COVID-19.
Although, just to add on there, you can file divorces online. This was a pre-COVID-19 thing. So everything can be filed online. So I'm not sure who was asking that question, but if you wish, you can always book a free consultation with one of us through our website, and I can guide you into how to process your divorce, even in time of COVID-19. It may not be processed till after, but at least you can do the paperwork and submit it. All right. Should I read the next question?
Yes, please.
All right, so I have one here. It says, I separated from my husband on February 15th, and we weren't able to hash out any elements of the separation agreement. Then the isolation order came, and so we've been continuing to stay together in the matrimonial home, though sleeping in separate rooms. You mentioned at the beginning that urgent issues related to matrimonial home may be considered by the court. He's seeking sole custody of our 4 kids and wants to buy me out of the home. And there's a history of gaslighting with him against me. It's quite a negative environment for me, and anxiety is high. I need to keep things moving, but feel like we're at a standstill. Could you maybe touch on what types of urgent financial matters could push the situation to action? So this was a question from an anonymous attendee. I wouldn't wait to either to start consulting a few lawyers to have a discussion about how you can move forward. This matter doesn't seem more, it seems more of a question that needs immediate action than just a question that needs answering. If you were to look into hiring a lawyer, at the least we could start with correspondence to your husband and possibly suggest that we hash out some terms via a separation agreement. And that may be a start, and it not just a start, it might allow you to end your matter before it gets even into the court system. And yeah, you guys can add on.
So I'm just going to add on, because the last question, or the last sentence, Lori says, could you maybe touch on what types of urgent financial matters could push this situation to action? So for example, I know we talked a little bit about putting up the the matrimonial home for sale, or if one party is in has dire financial circumstances, in a bad financial situation. Those are the kinds of things right now that would push the matter forward. But like Preet said, this is something that, you know, a lawyer could probably help hash out via separation agreement.
Yeah. So just reading the circumstances, I don't necessarily take any of that to be too urgent unless I don't have some of the facts.
Yeah, I'm just going to tack on to that. So the fact, and again, as Preet said, we don't know all the facts. So we're basing our answers off the limited information that we do have. But the fact that you are residing in the same property together would lead me to think that it might not amount to what are considered a dire financial circumstance. So when we talk about dire financial circumstances, I'm thinking more along the lines of an individual who they've now separated from their spouse, and that the spouse has completely cut them off financially. So they have no access to any funds whatsoever.
Yep.
They don't have a place to sleep. They have children to provide for. So a situation like that, to me, would rise to the level of, yes, we could proceed with an urgent financial matter. Again, we need to know a little bit more. But as Preet said, there are ways to resolve this out of court, and potentially hiring a lawyer and at least starting that process might be helpful.
I also want to add, for the urgency, especially for the financial matters, the judges want to see that you have tried to negotiate before bringing a motion. They want to see that you've given reasonable responses to each other, and you still can't come to an agreement. If you haven't talked to the other party first, the judges don't seem to like that very much.
Yeah, that's a great point, Anne. Next question.
Next question. I have Estelle Chang. The question is, how are expenses like insurance, car, and home, and the home mortgage split between myself and my soon-to-be ex? Is it 50-50 or on a sliding scale based on income? He makes 3 times as much as I do.
I can take this question.
I knew it.
I do like the financial questions. I do love math. So depending on, and there was no comment about whether they're common law or married or
living
in the
that's the
same
first
home.
thing I thought, yes.
Okay, so again, based on the information that is raised in this question, if you have a matrimonial home, so if you have a residence, if you're legally married and you had a residence together, regardless of who is on title, and regardless of whether or not someone has moved out of the property. So let's say, you yourself are residing in the matrimonial home and your spouse is residing somewhere else. The idea is that since the date of separation, until some future time when the property is sold or when one party buys out the other party's interests, the carrying costs related to the home, so the carrying costs being the mortgage, the property tax, the home insurance, and any necessary repairs and maintenance, those should be split 50-50. You raise a good point when you say that, your partner makes significantly more money than you do. So those expenses from date of separation until some future time, they're called post-separation adjustments. If you don't have the financial means to pay 50% of those expenses today, then when the property does get sold, your spouse or yourself could be credited for those payments. So they might be tacked on. So when the property sells, instead of splitting the net proceeds of sale 50-50, maybe you get 50% of the proceeds less your 50% share that you should have been contributing in post-separation adjustments. So that's the carrying cost. And then a second component to your question was with respect to maybe utilities or I think you said car insurance. So if you're now separated, the idea is that any expenses that you incur, you should pay. So if it's your car, you should be paying your car insurance, his cell phone bill, he should be paying. When it comes to utilities, the party that is residing in the home should be paying the utilities. If both parties are separated, living under the same roof, then the utilities, again, it's reasonable that they be split 50-50, but a calculation of that could be done at a later time if both parties don't have the financial means to pay those expenses equally right now. So that was a long answer.
That's okay.
Okay, sorry, Preet. I'm just going to go to another question that was emailed to us prior, but was after we set up the slides. This is a question from Victor. So he says that his wife has full custody of his adult children who are now 20 and 24. His son is in college and will be graduating next year. His daughter has finished her university degree, then completed 1-year diploma and is now enrolled in full-time master program. They both have part-time jobs, but I don't know where and how much they earn, as they are severely alienated. My question is, do I still have to continue paying child support even though you fulfilled your child support obligations? So child support obligations go usually only to the first university program, unless there is a history in the family of going to multiple programs. If both parents have master's degrees, then there is an argument to say that they should continue to pay child support going forward into those degrees, because it is something that is expected of them as children, or throughout their life they've always wanted to be going that far. Other than that, child support shouldn't be continuing. If you can try to negotiate first to see if you can stop them, but after the fact, if they can't agree, then you can bring a motion to change. Before just bringing a motion to change, I would see if you can contact each other and come to an agreement. This isn't an urgent matter per se, so I would say that you wouldn't be able to bring anything in court right now. So the best idea is to contact your ex-spouse and say your intentions of canceling, so that when you do bring your motion to change, you can go off from the time of the notice as opposed to when you file your motion to change. Then there's questions about claiming dependence on the income tax returns. We've discussed that already. Then there's the second question about his common law spouse who has passed away. Victor, we are family lawyers. Unfortunately, we don't deal with any estates or tax returns. For dealing with your wills or estates matter, you can contact Ivana at our office and do a free consult with her. And then for your tax return, I would say please contact your accountant.
That's good. Next one.
I've seen a question floating around, and I think only Emily and on our panel can answer this, since she practices criminal law. Can you speak about restraining orders in the case of marital abuse?
Yes, so this is a question from Sherry. So there's two types of restraining orders. There is one for family law, and there's also one in criminal law. If your spouse is abusing you physically or harassing you, then I would suggest that you call the police, and so you can get immediate help. If your spouse is charged with assault or any other criminal offense, then you will have that spouse will have conditions not to contact you. So that would be the fastest way if there is actual criminal charges that need to be laid. In family law, you can have restraining orders. You have to prove that there has been this abuse. There's specific forms that you have to fill out. But there has been 2 cases lately with COVID-19 that a judge has found that part of the restraining order was urgent to be dealt with. There was other issues in this matter, including access, but the judge did order for the restraining order to occur. Now, the difference between criminal restraining orders and family ones is the timeline. Criminal ones usually have a deadline of when they are terminated. And family ones usually continue for a long period of time and forever, unless a judge limits the amount of time that the restraining order exists. So if you need help immediately, call the police and get help through them. They will have the restraining order immediately, whereas it takes time to get one for family law.
All right, as I was typing this answer, and I know we can probably just answer it very briefly. How can I leave with an amicable separation?
I was typing the answer too, Priya.
Perfect. So I think amicable separations depend largely on the spouses or the partners. It's how you wish to exit your relationship. Sometimes it's best to talk at your kitchen table. Like in our graph, it showed that kitchen table discussions are always the first and foremost things we encourage at KPA. So if you're able to come to terms, then we can draft a separation agreement and you can both go on your merry ways and on a happy note with each other. And sometimes, yes, there's many issues that can't be determined between the parties because they can't see eye to eye on things. And perhaps Med Arb in that situation could be a better alternative than fighting it out in court. That would be my short answer. If any of the other panelists want to add on anything.
Yeah, there's only a few reasons usually I suggest to clients why a separation agreement might not be an option for them, or why lawyer-lawyer negotiations or kitchen table discussion, as Preet said. So if one party is refusing to provide financial disclosure, and you need financial disclosure because there's support issues and there's property division issues, the only way that you can compel the party to provide it is to start a court application because a judge is going to order it. So financial disclosure for us, I would say, is the most common reason why we have to start a court application. If there's a power imbalance, for example, if there's issues of abuse, that could be a common reason why a separation agreement might not be a viable option. And then just if the person is just not responding or they're refusing to get independent legal advice. So I'm dealing with that in a few files right now where we've sent kind of letter after letter and the other party is just dragging their heels.
Yep.
Or they're just, the challenge for them is they're not willing to get a lawyer, so they don't really know what their rights and obligations are. So those are, I would say, the most common reasons why maybe a court application is required. And just because you start a court application doesn't mean that it needs to continue on that path. In a lot of cases where someone's dragging their heels or they're maybe providing piecemeal financial disclosure, or they have a business and they're providing disclosure about their personal finances, but not with respect to the business. Maybe starting a court application is a necessary next step. And then once they're served, then all of a sudden they become very settlement focused as well.
All right, thank you, Sasha. Next question, very COVID-19 related. Can ex take child out of country if they had previous travel plans prior to COVID-19? Do I have rights to say I don't feel it is safe this summer to leave country given what's happening around the world? I think it's perfectly normal to say it's not safe leaving the country. I wouldn't let my child out of the country this summer.
Yeah, and I'm just gonna add on to that. There is a government travel advisory out. So, you know, your ex would really have to show why the kid needs to travel and if it's really the best interest. If it's not, it's probably not. You would have rights to say, I don't feel comfortable with this happening.
Yes, so if your spouse or partner does not want to take your recommendation of not leaving the country and you really do feel that it's in the best interest of your child to keep the child in the country given COVID-19, you should, this is a situation where I would indeed encourage my client to bring an emergency motion for the court's direction. All right. Our partner at the firm, Ryan, is trying to get someone in to the discussion who wishes to join us live, but I'll continue answering questions until.
Oh, I think she's there.
Yeah, she's here. Random, just so you know, if you want to, you can either have your video on and audio or just have your audio on.
At the moment, your video and audio are not on.
Learning technology, love it.
Oh, there she goes.
There.
Hi, Rano.
Hi.
Would you like to ask your question?
Yeah. Actually, I was married. It's about child support. I was married in 2005, December, in a place called St. Louis, Missouri, in the U.S.
Okay.
Mm-hmm.
I left. My son was born in 2007, and he was 7 months old, and I moved back to India. and I won my child custody case in Bombay, in the courts of Bombay, and my husband didn't contest it. I also did win a couple of criminal cases against him in India. But since we didn't have India and America don't share jurisdiction, I wanted to know. I am currently married now in Toronto. I moved here in 2018, and I remarried in 2019. My son moved with me here. He's 13 years old now. I wanted to know if I would be able to claim child support all the years that he hasn't paid, because I think between India and America there is a treaty. So I just wanted to know if I would be able to claim child support from 2007, and if I can yet claim child support even if I've been remarried now.
So I'll take a stab at your question right now. There's a lot of issues there.
Yes.
The first thing would be dealing with jurisdiction and enforcement of your India orders. You now that you and your child live in Canada, you could try to have those orders enforced here. If the judge finds that they won't enforce those orders, you could still start an application here for child support. The big thing is going to be serving him in the US, because it still has to be served personally. And the biggest question for you is going back till 2007. It's possible that a judge may allow that if they recognize your India orders. If they do not recognize your India orders, then there is a leading Supreme Court case called DBS that only allows people to go back 3 years unless there is exceptional circumstances. 3 years from the notice of asking for the support. Yep. So there's a lot of issues in your matter. I would definitely suggest booking a consultation with one of us, and we'd have to see what the best route for you would be.
And can I ask, do you have offices in the United States?
So we do not have offices in the United States, but Emily, I wanted to add on to that. There is something called the Interjurisdictional Support Unit, and they are around the world, depending on what countries Canada works with the Interjurisdictional Support Unit. And we don't need to have an office in another country. We just need to have access to the Interjurisdictional Support Unit to figure out support overseas and over different countries.
Okay, because I did have a lawyer who was helping me from New York, but whilst she contested it in St. Louis, I think they did it via email with the circuit court, I think. But the order, they said that she couldn't practice there since she didn't have a Missouri license.
Yes, that's correct. Most people can't practice in other states and other provinces unless you are called to the bar in the local jurisdiction which you practice in. For example, the 4 panelists today, all of us can only practice in Ontario. We cannot go into other provinces or other states in the US. But the Interjurisdictional Support Unit is somebody who allows us to communicate with the other court system on different levels.
Okay, so that would be the right way to go, and probably have a consultation with you guys.
Yes, most definitely. You can visit our website, and I think at some point Ryan will also be posting. Ryan's handling all of our IT for the firm through COVID-19, and we want to thank him for allowing us to do this and setting it up. So Ryan will be posting some links on, or you can visit our website and go to our lawyers, and you can book a consultation right there. You'll see all of our calendars available, and whatever time suits you, you just book it with one of us.
Okay, wonderful. Okay. Thank you guys so much.
Thank you. Thank you for joining us.
Okay, bye.
And Preet, want to read the next one?
Sure. Um, how does CPP get divided? So how do pensions get divided, guys?
So CPP gets divided once one of the parties claims for CPP. So if you're not retiring anytime soon, it's not going to be divided right now. It'll get divided later. And it's divided from the time of marriage to time of separation. I don't know if Sasha wants to add a little bit about that. You can definitely contract out of that in separation agreements if that's something that you like to do. But Sasha, do you have anything to add?
Well, I was going to say in a separation agreement, people will usually, like, there's usually a clause that just says, no, it just dawned on me. Both parties can apply for a CPP. I can't remember the exact language, but
it's the division, and
Yeah.
they do so the same way that you would when you apply for your CPP pension. When you do retire, the government pretty much does it automatically unless you have an agreement that says not to.
yeah, either party can apply for a Division of Canada pension plan credits. I think that's the typical language that goes into a separation agreement. And then obviously dealing with pensions is very different. But I know the question was just about CPP.
Yes. We know how much Sasha loves pensions. Sorry for my commentary. Next question. I'm not sure if I understand it, but let's see. Let's take a jab at it. If my partner and I do not reside in the same residential property, but during his scheduled access, he stayed with his daughter at my residence, can the mother suspend future access during the pandemic? Should I read it again?
Yes, thank you.
If my partner and I do not reside in the same residential property, but during his scheduled access, he stayed with his daughter at my residence, can the mother suspend further access during the pandemic? I'm going to assume that the participant is asking if they've done something to not comply with social distancing. Am I
Yeah.
getting the right way?
Yeah, I think so. So I think the mother of the child might use that as an excuse to say, well, you're exposing our child to a number of third parties. That's not in the child's best interest. I think that's where the question was headed, unless I'm mistaken.
Yeah.
I think it's saying that access is taking place at one of their residents, and they don't, and the person who his residence that is does not want them there anymore. But no matter how this question is being read,
different interpretations.
Yeah, it's, as we've talked about, you can't just, the courts have said you can't just stop access. If what you were previously doing with access does not work anymore, then you need to try to work together in order to find the best reasonable option to still have access if possible. And if it's being unreasonably withheld, then it may reach to urgency to bring a motion.
All right, next question. Can I be forced to sell the marital home? I officially own 60% of it. I am currently unemployed and need a place to live with my 2 children. These children are not his, and we have only been married since August 2019. So I take this to, nobody can force you to do anything. Nobody's going to force you to sign a contract unless the courts ordered it, and then you must comply or you will be in contempt of a order. But if perhaps, I think I would need a little bit more information on this question before I can give a thorough answer. I'm not sure if any of...
Yeah, can you reread that again? Sorry, I was taking notes on it.
That's fine. Can I be forced to sell the marital home? I officially own 60%. I am currently unemployed and need a place to live with my 2 children. These children are not his, and we only have been married since August 2019.
Yeah, so when I hear this question, I'm automatically, my mind is thinking about unequal division. So even though you've been married since August 2019, if you and your spouse resided together in a common law relationship prior to that, then that's important information for a family lawyer to know. I would say actually the opposite maybe of Preet. So if this matter went to court, because it is a matrimonial home, he does have an ownership interest in it. And you had said that you own 60%, he owns 40%. So potentially a judge could force the sale of the home. However, the fact that you are unemployed right now and you have 2 children living with you, is that in the best interest of the children? Because oftentimes that's the underlying test that judges will look at, especially if children are involved. What is in their best interest? Is it in their best interest to be homeless? No. And if you, depending on your financial circumstances, if you don't have another place where you and the children can reside, then maybe you would have, let's say, exclusive possession of the home for a period of time. But especially given everything that's going on in COVID-19, I don't think that this would amount to an emergency matter in terms of whether he wanted to force the sale of the home at this time.
All right, guys. I think we have Dee waiting to join us to ask a question. And I also want to mention to all the participants, we have an overwhelming response from everybody and many questions. And I don't think we'll get through all of the questions, but our panelist here will answer as many as possible, and we'll probably try and write some of the answers out to you. But if we don't get to you today, I'm going to let you all know that we are providing free consultations right now. We've suspended our consultation fees for everybody. And sorry. So Ryan, if we can have Dee join, that would be great.
I don't think Dee is there anymore. Preet.
Nope.
Oh, she's coming.
Right there.
It's here.
And then you just have to unmute your mic, I think, Dee.
So while Dee is dealing with trying to get her mic unmuted, I'll just do a quick question. So from the chat, there's a question that says, if written correctly, could a marriage agreement protect me from splitting my primary residence should something not work out? That's actually the usual reason for parties to make cohab agreements or marriage contracts in order to protect their current assets or future assets. So it's definitely available for you, and that is the purpose for these agreements. The biggest thing is to make sure that there is full and frank financial disclosure and independent legal advice for both parties to make sure that the marriage contract will stand if unfortunately something happens and your marriage doesn't work out. Oh, Dee
I think
is
we
gone.
lost Dee.
Yeah.
We have Alina.
We have Alina.
Yeah.
Alina, you have to unmute your mic. You can choose to display your video or not, but yeah, you have it. We can hear you, Alina.
Yeah, okay, thank you very much. Okay, girls, I have a quick question. I'm newcomer in Canada. I live in already 8 years in Canada, and half a year ago, I separated from my husband, living separate from him, and I have not started the paper process. And can you give me advice how I can start and where I should call and some contact?
So, Alina, do you currently reside with your partner?
Pardon?
Do you currently reside with your ex-partner?
Oh, sorry, I'm not understand.
Are you living with your ex-husband right now?
No, living separate.
You're living separate.
Yeah.
Okay.
Okay.
Are in my apartment.
Okay. And are you looking to start a separation and divorce process?
Yes.
Are you just looking for divorce, or are you looking for a division of assets that you own together, such as a home or bank accounts, pensions?
No, we have a prenuptial agreement.
Sorry.
Prenuptial agreement.
A prenup agreement.
Okay, you have a prenup agreement.
Prenup, yeah.
Okay, so that prenup agreement will dictate how you are going to move forward. A lot of prenup agreements, as they are referred to in the US, we usually refer to them as marriage contracts. They usually dictate how, if the parties were to separate, how you will move forward, which means, are you going to go to court? Are you going to arbitrate? Are you going to mediate? That is the biggest clause that we need to figure out before we can advise you on how you're going to move forward in the process.
Yeah, so what I would recommend, Alina, is if you made a consultation with the family lawyer. As I said, we're offering free consultations right now during COVID. And it would be helpful if you brought that prenup agreement to the consult, or sorry, I shouldn't say brought it in, because we're doing remote consultations at this time. But if you wanted to schedule a consultation with one of us, and you could always email a copy of the of the prenup agreement to us. That way we could review it. And we could give you some more information as to how the process moves forward. Because I will say that some people do have marriage contracts or prenup agreements, but they weren't well drafted. Neither party had lawyers, or maybe one party had a lawyer, and maybe there was no financial disclosure. So, I mean, until we see the agreement, it's difficult for us to know whether that agreement would be found to be legally binding if it was ever challenged. So that's what I would suggest, is booking a consultation and having one of us actually read through the prenup agreement with you, so that we could give you better, or give you some advice in terms of next steps.
I have another question. Do you have a free consultation?
Yes.
Yeah. Oh,
Yes.
okay.
You can go to our website and you can look at all the lawyers in the firm, and you can book with one of us. You will recognize our faces on the website.
Can you provide the website?
Yes, it's kpalawyers.ca.
Okay. KPA.
kpalawyers.ca. It'll also be listed on the link you used to join the webinar today.
Okay.
So you can it'll be listed there, and you can click on the link and get to our website.
Thank you very much.
Thank you, Alina.
Thank you, Alina. Moving on, another anonymous attendee. My mental health has deteriorated very badly. I want to leave the home and run away from this suffering. What are my rights? Will I lose everything I worked for? The stress is too much to handle.
So I think we need a little bit more information here in terms of what you're running away from, or what you plan on leaving, and what's happened for your mental health to deteriorate. So I would strongly suggest to book a consultation so we can get a little bit more information and see how we can help.
But in general, if you do leave your matrimonial home, you leave anything, you do not just automatically lose the right to your property, your ownership. But again, like Karishma said, I encourage you to contact us and we can talk confidentially in more detail. What are the technical/formal requirements of a separation agreement that is being drafted retroactively, i.e. separation occurred in 2005 and there are not any support claims? Do I need to get it notarized or witnessed by a lawyer still?
I was actually just trying to type an answer to that question, but I'll just say out my typed answer. So there's not really formal requirements for a separation agreement, but I'm sure all of the other girls here will agree with me that the biggest things that you need to make sure that you have in order for an agreement to stand is full and frank financial disclosure by both parties, and that both parties have received independent legal advice. So that's more than just being notarized and witnessed by a lawyer. That's a lawyer explaining the agreement and what your rights are outside what you're giving up in the agreement from your rights as from the Family Law Act and other acts. So to make sure that this gets upheld, you are going to want to speak to a lawyer and have independent legal advice. For the issue of arrears of support claims, in a separation agreement, you have, if both parties agree, then you can definitely waive any arrears of support. So that's not an issue. But if they don't agree, then arrears would be an issue that you need to deal with.
Yeah, and the only thing that question flags for me that you guys haven't addressed is the potential limitation period for equalization. So for property division, however, again, if it's in a separation agreement, as Emily said, there's what the law says. If this matter went to court, a judge is going to follow family law rules. However, if you guys agree to various things, like going back more than 3 years, for example, and seeking support arrears, and even though there's a statute of limitations for property division, it's 6 years from the date of separation or 2 years from the date of divorce. And I can't remember exactly when the date of separation was, but I know it was quite some time ago. You can still include all of those claims, even though technically there's a statute of limitations on it.
All right, I have another question here. I need help. My ex is withholding our daughter and twists everything I do. What can I do? So if you do have a order in place, and if you have an agreement in place and your ex-spouse is withholding your child in terms of access and custody, you most likely can bring a urgent motion or a case conference, depending on the status of your matter with the courts. However, if neither of those things have been initiated, like court or a separation agreement with a court order and a separation agreement, then we can still proceed to court to getting you access to your child if this is something that's happening very due to COVID-19.
Yeah, and sometimes I would just suggest in that case you retain a lawyer. Sometimes a letter from a lawyer can be helpful.
Yes.
Basically saying that unless there is a valid reason, unless your ex can present a valid reason as to why you should not have any access whatsoever with your child, he should be facilitating access. So sometimes a letter from a lawyer can be helpful in that instance.
I have a question. I'm just reading a question from Maria. My ex hasn't paid child support since October and hasn't seen my kids since September. I had a court order for April, but for obvious reasons it got canceled. Is there anything that I can do to enforce child support? So Maria, your court date for April, and the rest of the panelists can correct me if I'm wrong, it's not canceled, it's going to be adjourned. So your court case will be heard. The best bet right now is to try to, like we mentioned earlier, lawyer to lawyer negotiations can sometimes help. Unfortunately, Family Responsibility Office cannot enforce child support without a court order. They can only enforce orders. So when you do return to court for your adjournment, your child support claim would, of course, include these months as well, retroactively.
All right, I have another one here. If I choose to just leave and find an apartment and leave her in the condo, can I then settle with her after I leave because I'm suffering?
Absolutely.
Absolutely. That's the short answer. But if you do choose on leaving and you have found an apartment and you are now settled into your new place, I would encourage contact a lawyer. We can start the process of trying to divide your assets.
Okay, there's another question from Anonymous. I have been under self-isolation for 2 weeks following mild cough. I advised my ex whether you share 50-50 time with 3 kids, and she has them since. We agreed to that. At the end of the 2 weeks, I showed multiple symptoms of the virus and contacted our regional health unit, who ordered me under quarantine to await test results. I let her know immediately, but she contacted her lawyer saying I'm damaging the kids, I'm neglecting my children, and that I've been reckless. Our youngest is immunocompromised, and I don't want to take chances. Am I at risk for losing my parental arrangement, which has been court sanctioned? You are doing exactly what you're supposed to be doing. You want to make sure that you're staying away from your children when you have the suspicion of possibly having this virus. That will not be used against you going forward once you are better and you have, you can prove to the other side that you are no longer sick or have a possibility of the virus, then your parenting rights should be put back right in place. There may be some lag time just because we don't know how long people have the virus even after they stop having symptoms. But what I would say is make sure that you're having phone calls, video calls, texting with your children so that they know that you're still there and that you still care about them, and that you are staying away for their own safety.
Mm-hmm.
And like Emily said, that won't be used against you.
Sorry, guys, I'm trying to find COVID-19 related questions so that we can answer those, because they do have facts that are more urgent than other questions. But I think I've covered them all, and we can just speak about different ones. So I have just stopped on the screen. How long does a common law spouse have to file for spousal and child support if spouses abandoned home? Both of us are on title. My son at the time was 15, now 18.
So there's no real time restrictions in terms of requesting support be paid. Whereas I said previously, when it comes to property division, there are time restrictions in place. When it comes to child support, however, you could only make a claim for child support if the child is still deemed a child for support purposes. So you mentioned that the child is now 18 years of age. If the child is in a full-time program of study, then they can still be deemed a child and support should be paid. However, for example, if you wait too long and your child is no longer deemed a child, they've started working, or maybe they're taking some time off of school, post-secondary education, then you will not be able to make a claim for child support. So depending on what your child is currently doing, given that they're 18 years of age, I would say there is a sense of urgency in terms of if you're going to make a claim, it should be made sooner than later.
All right, thank you, Sasha. Another question, if the property tax payments for the matrimonial home went from the joint account, what is my eligibility for the share of matrimonial home? Again, a very vague question, who's on title? Is it a matrimonial home? First, we'd have to qualify it as that.
What was the question again, Preet? Sorry.
If the property tax payments for the matrimonial home went from the joint account, what is my eligibility for the share of matrimonial home?
So if it's a matrimonial home, and if it wasn't a short-term marriage, again, as Preet said, based on the limited information we have in this question, if it's not a short-term marriage, which means that it's 5 years or longer, which includes a period of cohabitation, then it doesn't really matter. It would be split 50-50, and there's always exceptions to every rule. But it's 50-50 division. And then post-separation, then there would be post-separation adjustments that need to be considered. So who's paying the carrying costs of the home? Those should be pretty much split 50-50.
Yep.
Yeah.
All right, the next one. An anonymous attendee is asking, my situation is as follows. Before 1 year, I made an assault case against my husband. The court gave him a peace bond order before 2 months. I applied for a divorce, sole custody for my 3 children, child support, and property equalization, which basically appears in a bank account. During this year, he transferred all the money from his account out of Canada and said it was a loan from his mother and brothers and made a fake paper to prove his lies. My question here, how I can prove that money is family property, and about the child support, will the court make him give me any, although he is unemployed? And if it has happened, then he decided to leave Canada once for all because we are not Canadian citizens to avoid paying any money. Who's going to take this one? This is long. I think I'm going to need a one-on-one discussion with this anonymous attendee. So if you are still a participant in this webinar, I will advise you to book a consultation, and you can book it with me. I would need to talk to you one-on-one and ask some more specific questions in order to provide you a thorough answer.
Yeah. Do we want to maybe just, in the interest of time, I know people have been listening for an hour and a half.
Yes.
Do you want to maybe just take one more question?
Sure. Which one of you has the most experience in family law?
The one reading that question. Preet has been practicing the longest.
All right. Guys, we all work as a team. If anybody's interested in talking to any one of us, you'll be surprised at how well we work as a team. So I'll add on that we're not your typical lawyers. We're better.
Can everyone see the last slide that I just posted?
No, you need to share your screens.
Okay. Sorry. Oops. Okay, sorry, I'll figure this out, but you can keep speaking.
All right. So my family moved into my spouse's parents' home to assist financially 2 years ago with his elderly parents. We are now discussing separation. I would like to move with myself and my children. Can he force my children to stay in his parents' home? He's trying to say this is best for the children. Again, I feel like the longer the paragraphs are, they're missing a lot of key information. But in general, we need to know more about how old the kids are, what the schools, what school the kids go to, the expenses of the house. Is it a matrimonial home? Who pays the bills? Who's on the mortgage? And these are just questions I'm thinking of off the top of my head to figure out what I could provide you as an answer. If anybody else wants to weigh in. So again, please book a consultation. We can have a more thorough discussion about what your options are and what your rights are. And that's that. So I think we've already gone 5 minutes over time, and I'd like to apologize to all the participants who didn't get their questions answered. But again, like we said before, we have free consultations available right now. So do book. Ryan has posted some of the links that are available to book us for the consultations, and we'll be more than happy to chat with you and answer any concerns, questions, or just simply what your rights are with the law. We don't mind chatting with anybody at this time. So please do book a consultation. We will call you and we can answer anything and everything you want to know about family law.
Yeah, and just to end off, I'm going to share my screen. Let me know if this works. Can everyone see that?
Not yet.
Double click.
There you go. And make it full screen, Sash.
Yeah, sorry, let me move this bar. Okay. Whoop.
Oh.
There we go.
Okay. So in terms of access to justice, with everything going on with COVID-19, I know lots of people have either lost their jobs or their hours have been cut, whatever the case may be. A lot of people are going through a difficult time right now, but that doesn't change the fact that people still have family law matters that they need to address, or whether they're contemplating separation or they're currently dealing with their separation agreement. So we just wanted to leave you off with some options that you have in terms of access to justice. So Legal Aid Ontario, if you make below a certain threshold in terms of income, you could contact Legal Aid. They will ask you a series of questions and you might qualify for a legal aid certificate. All of us speaking to you this evening, we are all on the family legal aid panel. So if you do have a legal aid certificate and you qualify for that, you can contact one of us. And there are many legal aid lawyers across Ontario. A second option is what's referred to as limited scope retainers. A limited scope retainer basically is where you hire a lawyer and you hire a lawyer for a very specific purpose. So for example, if you are interested in starting a court application, but you don't have the financial means to pay a lawyer to actually attend court with you, then you can hire a lawyer to simply draft court materials and to prepare you for court. That could be a great option. It helps keep your costs down. We have some clients that simply hire us to send an initial letter to the opposing party, or to, they'll hire us to draft a separation agreement, but we don't engage in lawyer-lawyer negotiations, for example. So it's a great option where you can still access legal services, but it's at a reduced cost because you're doing some of the work yourself and you're only hiring a lawyer for a specific purpose. Employee benefits, there are some benefit programs if you are employed where they offer legal services. So, I've had a few clients in the past where as part of their benefits package, they will pay for lawyers. So that's something you can look into if you do have a benefits plan. financing options. There are companies out there, and I can't remember the name of it, CFD, CDF, Canada Divorce Financing.
Yes.
They're a company that offers financing options. So if you're an individual, for example, if you're not currently working, but you do have an RSP, or you have, you have a matrimonial home or a rental property, for example, so you don't have access to funds immediately, but you want to start a family court proceeding or family law matter, there are companies out there that will assist. And then, as we said, we are offering free consultations right now over Zoom and over telephone. Just wanted to leave you on that note. Anything else, anyone?
I just wanted to thank everyone for asking such great questions and very in-depth questions, and we'll be more than willing to help you at our next Zoom webinar that we're going to be holding, as well as free consults whenever you book in.
Yeah, and I will say as well that pretty much every week or every other week we're doing family webinars, but other members of our firm are also doing webinars on various other subjects. So feel free to check out our website, and you can see what webinars are coming up in the next few weeks. Thanks very much for listening, everyone.
Thank
Thanks,
you, guys.
everyone.
Have a good night.
Thank you.
Bye.